Mr. President, members of the tribunal, as introduced earlier, my name is Mark Maxwell Peter, appearing for the appellant Ms. Tanks. I will address two issues in this hearing. The first concerns whether the GDC erred in convening the disciplinary tribunal in South Nagaland. Mr. President, I will structure my arguments and submissions in two parts. First, the legal framework, namely the Malaysian Arbitration Act 2005 and the qualifying game rules. And secondly, the relevant authorities and how they apply to the record before this tribunal to demonstrate why the tribunal in South Nagaland cannot stand. Mr. President, the governing law of this arbitration is Malaysian law, as clarified at paragraph 42 of the clarifications. Section 22 of the Malaysian Arbitration Act provides, and I quote, where the parties fail to agree, the seat shall be determined having regard to the circumstances of the case, including the convenience of the party. Mr. President, I would like to clarify that I refer to the seat here in a practical sense, which means the physical venue where the tribunal was convened, because of the procedural law, which is Malaysian law, has already been settled in clarifications, paragraph 42. This embodies the principles of procedural fairness that the chosen venue must not prejudice either side. In addition, Rule 23, subsection 1 of the qualifying game rules require that an internal tribunal be convened in a country where the tournament was held where reasonable practicable. That safeguard ensures hearing occur near the competition site and in an environment equally accessible to all participants. As the record shows at paragraph 25, the riots in Rambutana subsided within 3 days, and the tribunal was established 1 week later. It was therefore practicable to hold the hearing in Rambutana itself, as the rules require, by relocating the tribunal to South Nagaland, which houses the Federation's administrative office. The GDC disregarded both Section 22 of the Malaysian Act and Rule 23 of the qualifying game rules. This interpretation aligns with the 1997 Malaysian Federal Court's decision in R. Ramachandra and Industrial Court of Malaysia at paragraph 1, where the court held that the decision tainted by the procedural unfairness or bias is invalid. The GDC's relocation of the tribunal contravened not only the domestic...
Counsel.
Yes, Mr. President.
You mentioned the Malaysian case.
Yes, Mr. President.
Tell me about the facts of that case, please.
Certainly, Mr. President. So in this case, an employee challenged an industrial court decision in an unfair dismissal. The High Court initially refused to intervene, but the federal court ruled that the judicial review could examine both the process and the fairness of the tribunal's decision. The federal court held that the procedural unfairness or biasness renders a decision invalid, even if the outcome might otherwise be correct. This shows under Malaysian law, the procedural fairness is non-negotiable in quasi-judicial proceedings.
So you say it's non-negotiable, right?
Yes, Mr. President. And the same applies to the GDC's internal tribunal when it seated itself in its own headquarters. The GDC's relocation of the tribunal contravened not only with the domestic legal framework, but also the overarching principles of lex sportiva, which demands that the disciplinary bodies act impartially and avoid even the appearance of home court advantage. Mr. President, in the 2018 decision of Muthu and Switzerland, at paragraph 139 to 143, the courts explained that impartiality must satisfy both a subjective and an objective test, namely whether a reasonable observer would perceive the tribunal as independent. Applying that principle here, the seating of tribunal in South Nagaland creates an appearance of partiality because the GDC is institutionally tied to the organizing structure of the global games. The local law, administrative staff, and the facilities belong to the same federation overseeing the disciplinary process. And lastly, the procedural familiarity and logistical advantage favors the respondent, placing the athlete at a disadvantage. Furthermore, in the same case, at paragraph 182, the court stressed that the transparency and the public scrutiny are vital where an athlete's reputation is at stake. A tribunal convened under the shadow of respondents' own headquarters cannot meet that standard. And finally, in the 2010 CAS case of SC Sporting and Lujubinkovic at paragraph 33 to 39, the CAS panel reaffirmed that only an independent arbitration tribunal guaranteeing a fair proceedings and equal representation of both sides qualify as a legitimate forum under Article 22B of the FIFA regulations. The panel concluded that the Romanian Professional Football Teams Tribunal, whose members were appointed solely by the league's executive committee, could not be regarded as independent. This case establishes that even structural and institutional ties without the proof of subjective biases are sufficient to undermine the appearance of impartiality. Mr. President, members of the tribunal, for these very reasons, the appellant respectfully submits that GDC's internal tribunal was improperly convened in South Nangkalan. We pray that the tribunal to be convened in accordance with the Malaysian Arbitration Act and the principles of Lex Sportiva in either Rambutana or Lausanne. Only a true neutral venue can guarantee the independence, transparency, and fairness that athletes are entitled to under this international sporting law. Now, moving on to the next issue, Mr. President. The next issue relates to whether the GDC erred in declaring Ms. Tanks ineligible to participate in the qualifying games. We submit that the GDC acted ultra vires and in violation of both the qualifying game rules and Lex Sportiva. The GDC misinterpreted Rule 3 of the qualifying game rules, rewriting the standard of eligibility to require 100% Asian citizenship, thereby acting discriminatory and beyond its powers. Rule 3, subsection 1, provides that the person is eligible to be a participating athlete if he or she is a citizen or permanent resident of a country in Asia. There is no mention of exclusive or 100% Asian citizenship. By its plain meaning, the rule adopts an inclusive standard based on the citizenship of residents and not a restrictive test of purity of nationality. Any attempts by the GDC to narrow down its rules departs from the very text and violates the principles of legality and fairness under Lex Sportiva. As the record shows at paragraph 33, subsection B, the GDC held that Ms. Tanks was not 100% Asian citizen and therefore ineligible to participate. However, the additional requirements does not exist in the rules, and in doing so, GDC exceeded its interpretative powers and acted as a rule maker rather than a rule interpretator. In the year 2000 CAS case of ANS and Norwegian Wrestling Federation at paragraph 18, the panel held that when rules are ambiguous, they must be interpreted contra perferentum, which means against the drafting body, which usually is the sporting body. Similarly, in the 1991 CAS case of G and FEI at paragraph 7, the panel reiterated that the unclear regulations must not prejudice an athlete who rely on the published text. Applying these principles, any doubt in Rule 3 must be construed in favor of the athlete and not against her. Moreover, in the 2009 case of Telecom Egypt Club and Egyptian Football Association at paragraph 33, the panel held, and I quote, CAS cannot rewrite but only interpret rules set forth by the sporting authorities in light of the general principles of law. The GDC, by adding an unwritten requirement of sole nationality, effectively rewrote Rule 3 and thereby acted ultra vires. Furthermore, in the 1994 case of Puerto Rico Amateur Baseball Federation and United States Baseball at paragraph 1 and 2, the panel reaffirmed that each country has the sovereign right to determine its own nationality law, and the dual national athletes may freely choose nation to represent, provided that they have not represented
Counsel,
any. Yes, Mr. President.
You brought up the baseball case.
Yes, Mr. President.
Could you please tell me the facts of that case, Counsel?
Certainly, Mr. President. In the Puerto Rico Amateur Football Federation and USA Baseball, an athlete with a dual US and Puerto Rico nationality wanted to play for the nation of Puerto Rico in international competitions. The USFA Baseball challenged this decision, saying that he should only play for the United States. The CAS held that each sovereign state determined its own citizenship laws, and an athlete with a dual nationality is free to choose which country to
So
represent.
you're saying that an athlete with dual nationality is free to choose?
Yes, Mr. President. The athlete has its own autonomy to choose whether what country he or she wishes to participate and represent for.
Okay, thank you, counsel.
At page 9 of the award, Mr. President, may as I would like to quote a very exhaustive paragraph from the case decision itself. Would the tribunal prefer that I say the say the paragraph out loud to guide the tribunal?
Yes, go ahead, counsel.
Thank you, Mr. President. At page 9 of the award, the panel stated, and I quote, in circumstances of having a dual nationality, the choice of the NOC for which he wishes to compete is a matter of election by the athlete, subject to the certain variations of when an election has been made, whether either overtly or by implication, through an participation in a certain defined competition. It is common ground that the C, in this scenario, had in 1994 not competed in any such competitions for Puerto Rico, nor for the United States. He remained free, and therefore, in 1994, to elect for which one of the two countries he wished to play for. It made twice in the writing that he was to play for the respondent, and that was a choice which was open to C to make under Rule 46 Bylaw 1 of the 1994 Olympic Charter. Now moving forward, going back to our record, this approach is consistent with Rule 41 of the Bylaw 2 of the 2025 Olympic Charter, which expressly recognizes that the competitor who is a national of two or more countries may elect which country he or she wishes to represent. Lex Sportiva therefore safeguards the dual citizen autonomy in choosing representation subject to formal citizenship recognized by the state. Applying these very authorities to the record, Ms. Tang satisfies every requirement of Rule 3, subsection 1, such as she is a citizen of Durrania, an Asian country. She resided there for 9 years, and she never represented her birth country, Kyrgyzstan, an oceanic state. Her citizenship was validly conferred by Durrania, Durrania's sovereign law, and she submitted documentary proof of her domicile status as noted in paragraph 32 of the record. Under Puerto Rico, the Amateur Baseball Federation and United States Baseball and the 2025 Olympic Charter, she therefore has the right to elect and to represent Durrania. The GDC's decision to disregard her lawful citizenship and to demand 100% Asian origin was contrary to the Lex Sportiva and the principles of equality in sports. Finally, the GDC's approach undermines the consistency and fairness that the 1998 CAS case of AEK Athens and Slavia Prague at paragraph 15, Slavia Prague, which at paragraph 156 identifies as a fundamental to Lex Sportiva, which is the maintenance of uniform and predictability standard across international sports. If a dual citizen are excluded based on undefined regional purity, the integrity and the inclusivity of those international competitions would be seriously compromised. Mr. President, Ms. Tangs lawfully meets the eligible requirements under Rule 3, subsection 1. She is a recognized citizen of an Asian state, Durrania, and has never represented another country. And she was entitled under the Olympic Charter to elect her allegiance to a specific nation. By imposing an additional and discriminatory condition of, I quote, 100% Asian citizenship, the GDC acted ultra-vires. To summarize, Mr. President, both issues strike at the heart of the fairness of sport. First, GDC decisions to convene proceeding in South Nakaland, its own headquarters, undermine neutrality and procedural fairness. And second, on eligibility, the GDC exceeded its authority by rewriting Rule 3 to require 100% citizenship. CAS jurisprudence makes it clear that the sporting bodies interpret rules and do not invent them. We respectfully pray that the panel declare South Nakaland Tribunal invalid and affirm Ms. Tang's eligibility and restore the fairness, neutrality, and integrity owed to all athletes. Unless I can assist any further, Mr. President, I would like to conclude my argument. Thank you.
Thank you, counsel.
I think the second part was too lengthy. Yeah, I should not quote